Congress has a right to interpret the Constitution, right?
Correct, and a duty to do so.
Okay. What happens if Congress interprets the Constitution one way and the United States Supreme Court interprets it another? Who wins?
This hearing took a sharp turn when John Kennedy confronted judicial nominee Josh Flowers over a controversial constitutional theory that sounded, to many, like it could allow presidents to challenge court authority. Kennedy kept pressing one simple question. Can government officials ignore a federal court order if they disagree with it? What followed was a tense back and forth over presidential power, Supreme Court authority, and the limits of judicial rulings. And Kennedy was clearly not satisfied with the answers.
Congratulations, gentlemen. Mr. Flowers, I want to ask you about an article you wrote last year called Departmentalism in the Age of Trump. Do you remember that?
I do, Senator. It was a speech that I gave.
Yes, yeah. And as I read it, you espouse the view that each department of the federal government has a responsibility to interpret the Constitution. Did you mean each department or each branch? Tell me about that article.
They'd be synonymous in this context. So I was referring to both branches. The theory of departmentalism is the view.
So you were referring to branches?
Correct.
Okay.
Correct. And the theory of departmentalism, which Abraham Lincoln is perhaps the most prominent person to espouse it, is the view that every single federal official takes an oath to the Constitution and has a duty to abide by it. So you sometimes hear people say that the Constitution is what the courts say it is. And that's not quite right. Every official has a duty to interpret the Constitution. So, for example, if the Supreme Court okay.
I get it. So Congress has a right to interpret the Constitution, right?
Correct, and a duty to do so.
Okay. What happens if Congress interprets the Constitution one way and the United States Supreme Court interprets it another? Who wins?
So if that law is challenged in court, the court has a duty to say what the law is, and with respect to those parties, they'll issue a judgment. So with respect to those parties, they'll win.
I get all that, but who wins?
So in that case, the court would win with respect to the parties. The law would, Congress would be free to pass the same law again.
Given the fact that the executive branch and the legislative branch, the federal government, both have the authority to interpret the Constitution according to your theory, as well, of course, as the courts. Is there any, suppose the executive branch interprets the Constitution one way and the Supreme Court interprets it another way, who wins?
So the court will win when the case comes. The court will win in the sense that it will interpret the law, and its interpretation of the law will be binding on the parties in the case before it. But it's not necessarily binding on future parties. So the executive would be free to try the same thing again with another party.
So are you saying that if the president disagrees with an interpretation by the Supreme Court, but the president is not a party, the president can ignore the Supreme Court ruling?
But he could certainly not ignore the Supreme Court ruling with respect to the parties to whom the judgment applies. But Abraham Lincoln, famous...
I'm trying to get drilled down to understand, Counselor, what you really said. Let's suppose that the Supreme Court issued, well, let's take Calais, the Calais decision. Okay, the Supreme Court ruled. Some like it, some don't. The president was not a party, nor was Chairman Grassley. Mm-hmm. If they disagree with Calais, the president or Chairman Grassley, can they just ignore it? Is that what you're saying?
No, I wouldn't say ignore it. They're obligated to carry the judgment into effect insofar as
Tell me what you do. I'm confused. I'm sorry. I agree with you. Everybody should pay attention to the Constitution.
Can I provide a concrete example from history?
No, because I'm running out of time. I'm sorry. We'll talk about this later. I just don't. Do you think any of us have the right to defy a federal court order?
Generally, no, with an
What do
exception.
you mean generally?
So there's an exception for orders issued in cases where the court lacks jurisdiction, setting that aside.
Wait, there's an exception for what?
If a court issues an order in a case in which it lacks jurisdiction, then parties are not bound by that order. But generally speaking, they are
Why
bound.
don't you just appeal it in that case?
You can do that, but the courts have.
So if in your opinion, the court didn't have jurisdiction, you can ignore it?
Again, generally, no, but there's a long-stated exception in the law that courts have recognized for when the lower court lacked jurisdiction. Now, I would never advise a client to do that, because if you're wrong, that
I hope not.
right.
I mean, this business of ignoring a federal court order is nonsense. It's nonsense on stilts. You may not agree with a court order. That's fine. This is America. You don't have to agree with it. You can. That's why God made courts of appeal. But you're not suggesting that we don't all have to give me an instant. I'm way over. Give me an instance where you think a federal court order could be ignored.
The only one of which I'm aware is if a court had no jurisdiction over the case and issues the order anyway, and you don't follow it, you cannot later be held in contempt for doing so. But aside from that, parties must follow court orders.
Who gets to determine, this is my last question, Mr. Chairman, you've been very patient. Who gets to determine whether they lack jurisdiction?
Effectively, the appeals court. That's why I would never advise a client to do this, because if you're wrong that they lack jurisdiction, then you're going to be held in contempt.
All right, thank you.
What made this exchange so intense was that John Kennedy wasn't arguing about a specific court case. He was challenging a legal theory that goes to the heart of how the American government works. Kennedy questioned judicial nominee Josh Flowers about a speech discussing departmentalism, the idea that each branch of government has its own duty to interpret the Constitution. At first, the discussion sounded academic. But then Kennedy zeroed in on the question everyone was thinking. If the Supreme Court interprets the Constitution one way and the President disagrees, who wins? Flowers argued that court rulings are binding on the parties involved in a case, but Kennedy repeatedly pushed back, trying to determine whether that logic could allow government officials to sidestep court decisions. The most heated moment came when Kennedy challenged the idea that any federal court order could be ignored. Calling the concept nonsense on stilts, he argued that disagreements with judges should be settled through appeals, not by refusing to comply. Flowers responded that there is a narrow legal exception involving cases where a court lacks jurisdiction, but he also emphasized that he would never advise a client to ignore a court order because the risks are enormous if the court is later found to have acted properly. By the end, the hearing had become a much bigger debate about presidential power, judicial authority, constitutional interpretation, and whether any branch of government can act independently of the courts. That's why this clip caught so much attention. Because underneath the legal jargon was a fundamental question. Who has the final say in America, the elected branches of government, or the courts? Subscribe for more explosive hearing breakdowns and major constitutional debates. Like the video, share it, and comment below. Was Kennedy defending the rule of law, or was he misrepresenting Flowers' legal argument?